Welcome back to Navigating Estate Planning with Caress Law. We hope you're enjoying the show. Before we dive into today's topic, we have a quick request for you, our listeners. If you're enjoying the podcast and finding value in the content we're providing, we would greatly appreciate it if you could take a moment and support us by leaving a 5-star review on Google. This review helps us reach more people who might benefit from the information and insights we share here on the show. Plus, it lets us know what you like and how we can continue to improve. So if you're finding our podcast helpful and informative, please take a moment to give a 5-star review on Google. It only takes a minute, but it makes a huge difference for us. And also, don't forget to leave a comment too. We love hearing from our listeners, and your feedback helps us shape future episodes. So please help us spread the word and get the conversation going. Thank you so much for your support. I'm your host today, Tammi Caress, founder of Caress Law. And today's topic I am actually very excited about. Unfortunately, there have been too many times in my 20 years of practice where I have found out relevant information after my client has passed. And it's information that had I known prior to, we could have provided a better plan for that situation. So I wanted to go through some of those scenarios with you today to hopefully help you so that you don't make those same mistakes. And now it's time for the disclaimer. The information contained in this podcast and associated material is intended to furnish listeners and users with general information on matters that they may find to be of interest. The information in this podcast provided by Caress Law and its agents are for general guidance and is not intended to replace or serve as a substitute for any advisory, tax, estate planning, or other professional or legal advice, consultation, or service. Sometimes we may reference third-party materials or websites. Such links or references are only for the convenience of the listener, user, or browser. Caress Law and its agents do not recommend or endorse the content of third-party information or sites. You should consult with appropriate Caress Law professionals or other professional advisors for advice concerning specific tax, estate planning, or other matters before making any decision. In summary, this podcast is not legal advice. If you need legal advice or before acting or making any decision with anything talked about in the podcast, seek the counsel of an attorney. Thanks so much. Transparency is super essential when you're talking with your estate planning attorney. So, of course, when you choose your estate planning attorney, choose someone that you feel comfortable with, someone that you relate to, someone that you can trust. Because trust is essential, because as an attorney representing you the most effectively that I can, I want to make sure that I know everything I need to do my job to the best of my ability. So transparency is key. So sometimes those family dynamics, those family conflicts, I know it's uncomfortable to share, but it's going to help you safeguard your legacy and protect your loved ones later on if I know these scenarios. So one big one that has come up in recent years has been the knowledge about a beneficiary or even a trustee or a personal representative or an agent under a power of attorney, anyone that you're assigning a role to do, or anyone that you are going to give money or inheritance to when you pass. I need to know, does that person have a history, either current or in the past, of drug or alcohol dependency? This is huge. I cannot tell you how many times, well, actually, I probably could, but there's so many times that this information would have been super helpful and we could have really planned for it so that we set up that beneficiary to be in a position where they're going to be healthy and not put them in a position where they're going to go down the wrong path even further. So there's lots of protections that can be set up in an estate plan. And I can give you an example. I have had a client who passed away that I have known this client for years. And unfortunately, this client didn't divulge the scenario with his child. And this child actually does have some dependency issues, is on state assistance. And it's those kind of things that had I known, we could have set up better protections into the trust to make sure that she's provided for throughout her lifetime, but we are not putting her in a position to have a lot of money to be able to use it towards her alcohol dependency. So this would be something that would have been super relevant for me to know about prior to. And I know it's hard, and sometimes it's really hard to admit to yourself that these might be some problems. But even if you think there might be a problem, but you're not sure, please bring it up with your estate planning attorney. We can make sure your assets are protected for that beneficiary, so that beneficiary can actually flourish, instead of putting them in a position to where maybe they go down the path even further. So any beneficiary who has a drug or alcohol dependency, or any person that you're going to name to do something for you when you pass or for you during your lifetime, like handle finances, settle your estate, those kind of things, we probably need to know if you're naming a person who might have or has had some drug or alcohol dependency in the past. And there are other options and avenues that we can explore with you. But here, the goal is to protect your family. And I know sometimes people make these decisions. They want to treat everybody the same. But you know what? If Sally has a dependency and it's a real dependency, we want to put protections in place. And what's more important to you? Hurting Sally's feelings or protecting her? Usually it's the latter. But it is my clients, I think, who feel like, oh, I'm going to hurt their feelings if I do it in this way. And it's like, you might hurt their feelings, but would you rather hurt their feelings and protect the assets for them? Or would you rather give them the assets and help them spiral down a road that you don't want them to go down? So really important to know about those situations. I just have a lot of clients who are worried to do certain things because they don't want to hurt a beneficiary's feelings. And that's not the best place to come from when you're really trying to support and protect them. I've even had clients write a letter explaining, hey, I love you very much. This is why I'm doing this. And I really don't want to hurt your feelings, but I want to make sure that you're protected, and I'm doing this because I love you. You know, there's things that you can do to hopefully help that scenario. Okay, I've talked about that a lot. The next one is a live-in person in your home. Usually it's an adult. A lot of times it could be an adult child or an adult grandchild. It could be a niece or nephew, any adult person who you're not married to. Usually when you're married, we're doing this plan together. But if you are married and you're doing it separately, of course, so that's information we need to know about and plan for. But I'm really talking about that adult person who is living in your home. The reason we need to know about these things is because it poses a potential challenge when you pass away regarding that person and how long they can stay in the home. What do they have to pay rent? Are they responsible for paying utilities? And unfortunately, we've had to deal with several situations where we have had an adult living in the home. Usually it's an adult child, an older adult child, who once parent has passed, that person needs to move because that's house is an asset. We have to sell it and disperse the proceeds to the beneficiaries. And we can set up a plan to make that transition easier for that adult, and also to make it very aware to anyone who is involved in the matter after you're gone that this adult, has to pay rent, doesn't have to pay rent, is responsible for this. How long can they stay in the house after death? You lay out those terms and be as clear as possible so that you have a direct path for the trustee to follow, or the personal representative under a will, your fiduciary, the person, I'm going to say trustee a lot, but basically it's any person who is who has that task of settling your estate once you passed. Okay. So when I say trustee, it's kind of applicable across the board. But we want a roadmap for that trustee to be able to follow. And we also want the beneficiaries to see the roadmap. And if the beneficiary who's living in the house sees that, oh, okay, well, I have 3 months to kind of get myself packed up and moved and find a new place to live, that make them put them in a better position because they know and understand that's what the deceased person wanted. Now, if the document is silent regarding that, what do? Well, hopefully, our first action is always to talk to the person living in the home, find out their plans, and hopefully we can all work together in how the transition is going to occur. But unfortunately, that is not always the case. It's the best case scenario in this situation, but it's not always what happens. Oftentimes we have someone who never really left home. They might be an older adult, in their 50s, and they really just lived off of mom or dad, and mom or dad is gone, and now this house is owned by multiple beneficiaries, or the estate owns it and multiple beneficiaries are entitled to it. And we have to get that person out. And if they don't cooperate in leaving, we have to actually go through a court process to get them ejected. Now, lots of times the trustee or the person tasked to do this is related to the person who's staying in the home. A lot of times they're a sibling, or maybe they're an aunt or an uncle or something like that. And now you have put them and their relationship in jeopardy because they're in this position to where they have to get you out of there or get the person out of there to sell the home. That's their fiduciary obligation. And you are basically destroying that relationship. So super important. I can't tell you how many times I have later on found out that a client of mine had a girlfriend living in the home, had no idea they had a girlfriend, like an older client of mine, or they had, sister-in-law or something like that in the home. And they provided this person with a car to drive, but this person doesn't own the car. My client owns the car. And I find these things out and I'm like, we need to make sure we have a clear path of what needs to happen. So informing your attorney of those details, super, super important. The other is family members who were not blood related. Your estate planning attorney needs to know who those people are. Why? There's so many times where we have an intake form that asks for the family members' names, children's, grandchildren, beneficiaries who are inheriting from you that could be nieces or nephews. A lot of people might call someone their child when they're actually not. Maybe it's a stepchild, or maybe it's a grandchild from your son or daughter's spouse. Those people are not considered blood relations under the law. And so we need to know that. And if you want to treat those non-blood related people the same, we need to know who those people are, and we need to define them within the document so that they are treated the same. But if we don't know that they're treated the same, I had an estate plan come to me where we did everything, and then 2 years later they came back, and 2 years later is when I found out that the children listed in the will were not actually the children, and I didn't know that. So, we need to know, because a lot of times someone will call a grandchild when they're not a blood related grandchild. So we need to know that information. Family members or beneficiaries that have special needs. So we need to know what those are. We need to know if there's a potential that beneficiary will be on government provided assistance. Maybe they are now, or they will be in the future. That's because if they are going to be on government provided assistance in the future, we may have to set up their inheritance in such a way so that the state doesn't take it once that beneficiary passes. We also may want to set up the estate plan in a certain way so that beneficiary doesn't get pushed off of the government assistance when they inherit assets. So super important to know if they're special needs beneficiaries. And even if they are not on government assistance, there's certain scenarios or certain ways to disperse assets so that that beneficiary is still protected, has the ability to benefit from those assets, but maybe they're not the one in control because they simply just can't be in control. So very important to know if there's any special needs beneficiaries. Okay, family dynamics are super important in any potential challenges. Present family conflicts are important to know, and any anticipated conflicts that could occur at death are super important to know. An example might be maybe you have two beneficiaries who are brothers, but they're estranged from one another, or they don't get along at all. It would not be a good idea to name one of those brothers as a trustee of your trust or personal representative of your will. It would not be a good idea to name them together, to serve together. And I have seen that a lot because the client comes in and they say, well, my children don't get along at all, so I'm just going to have them serve together when they're settling my estate. Terrible idea. Terrible, 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 terrible idea. So that sort of situation we need to know about. Are there any estranged relationships? Are you estranged from your child or grandchild? And if so, how do we want to deal with that? Do you still want them to inherit? Do you maybe don't want them to inherit, but maybe their son or daughter or their children needs you want to inherit? So we need to know about those estranged relationships from you as the client, but also to the beneficiaries that you are provided for under your will or trust. We need to know if they get along. And it's really, really important when we're assigning roles of who's going to settle the estate, who's going to be the healthcare representative, those kind of things. We need to know family dynamics so that we can best establish a plan to minimize any sort of conflict. Another example could be a family home. I've had clients who have passed who've lived in a home that they built themselves. And they have multiple children, and they have some children who say, well, we want to sell the home. We have other children that say, no, we're going to keep the home. And there's some family conflict and family dynamic in there around what to do with the home. Well, we can address that in your estate plan, and we can figure out a good plan so that we can try to minimize those family conflicts. It's going to help us anticipate any sort of issues. Okay. International considerations. Do you have property outside the US? And if so, where? And have you planned for that property with an attorney in that jurisdiction? I'm going to tell you that when I have clients that come to me that own property outside the US, if it's in Canada, we're usually talking to an attorney there, making sure that the estate plan in Canada and the estate plan in the US works together. So we're doing that a lot. There are some countries who their way of passing assets are a lot different than the US. So we need to know that because we're probably going to need to get an attorney in that other jurisdiction involved. And we're going to need to make sure our plans here and our plans there match. Okay. The other thing is, are there beneficiaries outside of the US who will be inheriting? And I know this is becoming more and more common in the kind of digital age that we have. It's good to know that, mainly because it doesn't prevent them from inheriting, but there could be some issues on their end that they maybe need to work out. There could be some inheritance tax on their end because of the country they live in. We don't know what those are if we don't know beneficiaries are residing outside the US. The other huge thing is your health status. If you are coming to me because you have been diagnosed with a terminal condition, I want to know that. Why? There are things that we could do now to possibly minimize estate taxes. There are things that we could do now to make sure that your pets are provided for right now. We want to plan. Estate planning isn't just planning for your death, it's planning for your life right now, planning for your incapacity. But it saddens me when there are moments that I find out that I met with a client who seemed completely healthy and they didn't disclose that they had a terminal illness or they weren't expected to live beyond 6 months. And then we put their estate plan in place and then they pass. Well, had I known, there might have been some things that we could have done to minimize estate taxes and so forth. It's just really good for the attorney to know if there's any sort of health status or health condition so that we can make sure we're supporting you and providing the best plan in place. Lastly, changes in circumstances. Keep me informed or keep your attorney informed if there's any significant changes in your life. That would be a marriage, it's a divorce, it's a birth, it's an adoption, it's a change in financial status and your health issues like I just talked about. That way we can make sure that your estate plan is updated, remains current and effective, and actually does what you need it to do both during your lifetime and once you've passed. Okay? So that's the end of today's episode. I hope you've gained valuable insight into the significance of open communication with your estate planning attorney. By sharing those private details of your life, you're going to empower yourself and you're going to empower your attorney to craft the most comprehensive plan that reflects your wishes and protects your legacy. If you have any questions or topics you'd like us to discuss in future episodes, please reach out, leave a comment. Your feedback is super valuable to us. Thank you for tuning in to Navigating Estate Planning with Caress Law. Be sure to subscribe for more discussions on estate planning and other essential topics. And until next time, take care and plan wisely.